Hello there, I'm Laura McHarrie at The Hidden Edge with another tea break tip on business models and tools to help you manage your growing business. Today, we're looking at the 5 fair reasons for dismissal and employment tribunals, essential information for employers to keep on the right side of the law. Dismissals are classed as automatically unfair if the reason for dismissal is connected with an employee's exercising specific rights in relation to pregnancy, family reasons, representing somebody else, trade union membership, part and fixed term employees, pay and working hours, including the working time regulations, annual leave and the national minimum wage. So what is a fair dismissal then? Is there such a thing? Well, let's have a look. There are 5 fair dismissal reasons: misconduct, capability, redundancy, legal restriction, and some other substantial reason. There used to be a 6th reason, retirement, but the default retirement age was abolished in 2011. Misconduct. Continuing misconduct will eventually result in dismissal on the grounds of misconduct. Very serious conduct issues such as theft, discriminatory behaviour are usually regarded as gross misconduct, and after an investigation, a gross misconduct finding can result in an employee summary dismissal, that is, without notice. Capability. Capability can include ill health if an employee, for example, has a long-term or persistent illness such as cancer that makes it difficult for them to do their job. But before you dismiss, as an employer, you'll need to consider how the employee can be supportive, give the employee some time to recover and to monitor the situation, have a full understanding of the employee's condition, treatment, and likely prognosis, and have considered other options for them: change of role, part-time working, flexible working, for example. Poor performance, however, is when an employee is not capable of performing to a satisfactory standard within their role. In this case, prior to dismissal, the employer would usually be obliged to follow their performance management process, which is likely to include going through disciplinary warnings and giving the employee at every stage of the process time to improve, plus support and training if necessary. Redundancy. A redundancy is when an employer requires fewer or no workers. For example, if you're closing down, if there is less work for employees to complete, if you're moving, changing locations, if one particular role or function is no longer required, and if there is a reorganization of the work, meaning that there are fewer jobs or new jobs which are different to the old ones. Legal restrictions. This would be used when continuing to employ somebody would mean that you are breaking the law. So, for example, if you employ a lorry driver and they lose their driving license, and of course you have no other work for them, then the employee's right to work in the UK expires. You would still need to go through the formal dismissal procedure as in your terms and conditions of employment. And the last one, some other substantial reason. It's the catch-all. And to some extent it is true when, of course, the dismissals don't fit into any of the other 4 categories. There isn't a legal definition for this, but here are some examples of where it might be applied. If there is a significant conflict of interest in one of your senior employees whose partner works for a competitor, if there is a personality clash that causes substantial issues to the business, if there is an expiry of a fixed term contract, when an employee doesn't agree to changes in their terms and conditions, you could potentially dismiss them and re-engage them on new terms and conditions. You would need to go through the consultation process before you did this, though. Throughout any disciplinary or dismissal procedures, the ACAS guidelines advice suggests that you should raise and deal with issues promptly and should not unreasonably delay meetings, decisions, or confirmation of those decisions. You should act consistently. You should carry out any necessary investigations to establish the facts of the case. You should inform employees of the basis of the problem and give them the opportunity to put their case before any decisions are made. You should allow employees to be accompanied at any formal disciplinary or grievance meeting. And you should allow an employee to appeal against any formal decision made. On a scale of 1 to 5, with 5 being fab, rate yourself and your business on how well those guidelines are put into practice within your organisation. You can be taken to an employment tribunal by an employee over various issues, including pay, dismissal, and discrimination. The employment tribunals are an independent judiciary body established to resolve disputes between employers and employees over employment rights. The tribunal will hear claims about employment matters such as unfair dismissal, discrimination, wages, and redundancy payments. Tribunals are less formal than a court. For example, no one wears a wig or a gown. However, like a court, tribunals cannot give out legal advice. Almost all hearings are open to the public, and evidence will be given under oath or affirmation. In the event of a claim, you will be contacted by ACAS, the Advisory, Conciliation and Arbitration Service. They will offer to work with you and the claimant to try and solve the problem without it going to a tribunal. This is called conciliation. The tribunal will send you a letter if the claim has been made against you and the conciliation hasn't worked, in which case you need to respond within 28 days. You can bring witnesses to the hearing if they can give evidence directly relevant to the case. If you ask a witness to attend and they don't want to, you can ask the tribunal to order them to come. You must apply in writing to the tribunal office dealing with the case, giving them the names and addresses of the witnesses, details of what the witness may be able to say, and how it will help the case. The reason the witness has refused to attend if they gave you one, and you will most likely be responsible for paying the witness's expenses. You will present your case to the tribunal. Somebody else can do this for you, so that may require hiring a lawyer. The claimant will present their case against you. You may be asked questions by the judge, the claimant, and 2 other tribunal members. If you win the case, you won't be awarded any compensation. However, if the claimant acted unreasonably or if their case had no hope of success, you can ask to be awarded costs by the tribunal. But if you lose the case, then the tribunal can order you to do certain things depending on the type. You may be required to give the claimant back their job, pay compensation if you can't give the claimant back their job, pay witness expenses, pay damages on loss of earnings, and paying the claimant's tribunal fees. Paying compensation is the most common outcome of a tribunal. There can be limits to the amount of money a tribunal can award. You may also have to pay back any job seekers allowance, income support, or employment support allowance. If you disagree with the tribunal decision, you can ask the tribunal to reconsider. You must write within 14 days, and there is a fee to be paid if you wish to appeal. Employees may have claims against their employer under both their contract of employment and any relevant statute. And these claims may arise on recruitment during employment or on termination. In many cases, the employer will want to make a payment to the employee in return for an effective waiver of such claims. This saves huge time and costs for both parties and is called the compromise agreement. The employee receives an agreed sum under the agreement, which can often be paid tax-free in return for not bringing the claim. So there you go, in a nutshell, the 5 fair reasons for dismissal and what happens if you don't use those. Do download the templates from the Hidden Edge website, and whilst you're there, please share your stories of where this has worked or hasn't worked for you, because I'm building a portfolio of case studies and would love to include yours within that. So until next tea break time, enjoy the rest of this one.